Thank you, President, Commissioner McGrath. 10 million people become victims of crime every year in the European Union, and huge numbers of these crimes go unreported, and thus victims remain unprotected themselves, and justice systems and law enforcement are badly affected. Also, we see a fragmented legislation at national level with uneven treatment for victims and very different standards in protection. While at the same time we know that reporting and judicial procedures may represent an extremely cumbersome task for many victims, if not a painful and stressing experience. It is against this background that the Parliament started in the previous mandate a long discussion and a complex negotiations which has resulted in a revised directive that is highly satisfactory and make a substantial improvement in the status of victims and the protection of their rights. For the first time, the directive introduces specific obligations for Member States to ensure that victims who suffer additional harm due to the glorification of serious criminal offences can access support and protection measures. Also, the agreement establishes a privacy by default system, ensuring that victims' personal data will not be accessible to offenders unless strictly necessary. And that represents a substantial improvement of victim safety and trust in judicial procedures. Member States must provide accessible, secure and user-friendly reporting channels, including digital tools. And we do expect that this will reduce underreporting and enable early intervention by competent authorities. The directive provides for the establishment of EU-wide helplines, strengthen access to effective legal assistance, and development of specialised support services, including shelters, while improving the conditions for victims participating in cross-border criminal proceedings. Victims will have the right to receive all relevant information about their case, including an offender's release, transfer, change of regime, or early termination of a criminal responsibility. And judicial review will be also a right to the review of decisions taken in the course of the proceeding on the right to translation, the right to be heard, and the right to legal assistance when these decisions are taken in the course of the procedure. Recital 7 was key for a final compromise, and we had to reconcile the concern and support to victims of sexual violence with a legally sound provision. And I think we got this balance in Recital 7. Sexual and reproductive health services are mentioned in the recital, not in the operative part of the text. They are mentioned by way of example, so the directive doesn't intend to set up a list, a European list of sexual and reproductive health services. They are referred to as services, and the very recital clearly reasserts the national competence in the choice, the definition and the delivery of these services according to national laws, constitutional frameworks and according to Article 168, paragraph 7 of the Treaty of the Functioning of the European Union. So let me tell you that the outcome is entirely positive and satisfactory for those who have been so closely involved as my case as rapporteur and co-rapporteur along with my colleague Lucia Yar. And it's entirely positive, not only because I do think that it will gather a huge support from the Parliament, but also it really makes a difference, a substantial improvement in the status of victims, the support they are entitled to receive. Thank you.
Merci beaucoup, Monsieur le rapporteur. Je donne la parole à Lucia Yar, rapporteure pour le Parlement.